Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are discussing the grounds for acquittal of the death sentence of an accused person by the Honorable Supreme Court of India. Death sentence, but Supreme Court rejected the same. So the appeal filed by the accused person has been allowed. How? What are the grounds for acquittal of the important case? We have to know. Death sentence imposed by the trial court and confirmed by High Court or without any cogent evidence. Ultimately, the Supreme Court acquitted for the alleged rape and murder of a minor, that is 6 years girl. Justice S. Abdul Nazir, A.S. Bopanna and V. Ramasubramaniam, 3 judges bench. They allowed the appeal in the case of Chotkau, Chotkau. This becomes a very good case. Chotkau versus State of UP, 2022, in criminal appeal number 361 and 362 by 2018, disposed on 28/9/2022, and acquitted the man who was sentenced to death for the alleged rape and murder of 6 years old. Good. Now, if you know the facts of the case, please remember, here the prosecution case is that the accused person took the deceased, who was just 6 years old, on 8/3/2012 under the pretext of showing her the dance and song performance on the eve of Holi. And after the function is over, he took her to an isolated place where he committed rape on her. When she resisted or when she cried, he killed her and left the body in the sugarcane field. The body was traced on the next day in the sugarcane field, and PWS 123 deposed in favor of that they have seen the dead body and things like that. A case was registered and the accused has been arrested. The routine procedure followed and death sentence was offered or ordered to the accused person. As per section 366 of the CRPC, it was also confirmed to the High Court. Now he had an appeal. So appeal was dismissed by the Honorable High Court of Allahabad. Ultimately, the matter came to the Supreme Court. Supreme Court, having perused the judgment, having perused the statements of the witnesses. So here, please remember, the trial court should be very, very cautious, particularly in cases where they are awarding death sentence. Death sentence cannot be given in a routine manner. It should be given only in cases which are rarest, which are deemed to be rarest of rare. So of course, in Supreme Court, rarest of rare, rape and murder of a minor child, definitely it is considered as a rape, as a rarest of rare case. But please remember, right from the beginning, the accused has been defleading that the case was foisted against him under the influence of a local pradhan, whose wife is the local some sarpanch thing like that. And secondly, he was so poor that he could not engage even a lawyer in the sessions court. So legal aid was given to him. Even some organization took up his case and sent the same to the Supreme Court in the shape of SLP. Right? So please remember, the Sessions Court convicted him under section 302 and 376 IPC and awarded death sentence. So now, please remember, the important lacunae in the trial, in the trial part. So please remember, the faults have been noted chronologically. I think better we know them. So first, place where the dead body was first seen the police. It's totally confusing because one person, PW1, stated that he was going to his fields along the road and he found the dead body in the sugarcane field. But in the cross-examination, he admitted that he has no land via that route. Then how can you believe him? Second point, person who took the dead body. Who is the first person that took the dead body from the place to the actual house of the deceased? It is not clearly established. Number 3, place to which the dead body was taken. They say that the body was kept on the road, body was taken to the house. So many things, different versions in PWS 1, 2, 3 came. It is not conclusively proved that the body was taken to some place. Then, more important, difference in the versions of PW 1, 2, 3 regarding the place, date and time of so-called conduct of conduct of the inquest. So normally it is a very clear evidence that the police will conduct the inquest to know the apparent cause of death, but they have given different times, places, because the inquest would have been conducted in the hospital, I believe, right? So the PWs 1, 2, 3, the evidence is totally contradictory. Therefore, it is held untrustworthy. But the trial court, the sessions court, or they have, for that matter, the high court, they have taken as a very minor dispositions. So they took it in a light way, minor contradictions. And important point is, there is a delay of 5 days for the FIR to be forwarded before the concerned jurisdiction court. So normally you may be knowing they have to send express. When it is a murder case, you have to send the express FIR. That means immediately you have to send a copy to the local magistrate, to the SP, to the collector and others. But here the time noted by the judge is that it reached it after 5 days. That too incidentally, please remember, on the day when the PM certificate has been obtained. Right? The PM, even the most important point is, the accused was not sent for medical examination under section 53A CRPC, which is fatal to the prosecution. And another failure to obtain the forensics laboratory on the clothes, that is blood or semen present on the salwar worn by the victim at the time of incident. They have failed to obtain the same. When these lacunae are there, how can you award death sentence simply saying that these are all minor contradictions? It's not correct. This is what is held by the Honorable Supreme Court of India. It said, when the offence is heinous, court is required to put evidence under high scrutiny. So, PM was done on, postmortem was done on 13/3/2012, and the report was obtained on 13/3. Done on 9/3, report was obtained on 13/3. 5 days gap. On the same day, the FIR was reached in the court. That means there is some connection. So, accused is falsely implicated. Even though the lower court and the high court held him responsible, Supreme Court, with its vision, it has come to the correct conclusion that the offence was falsely implicated against him. Result, acquittal. So, for acquittal, if you want to argue this case, beautiful, one of the best cases, that's why I told you, it will be a landmark judgment for acquittal. Please read the judgment and enrich your legal knowledge. Thank you.